Today's session will focus on arbitrator training. We'll be kicking off with a panel discussion on pre-appointment checks and disclosures, accepting an appointment as an arbitrator, running an efficient arbitration, managing parties and counsel, and working effectively with fellow arbitrators. The faculty for this segment are Mr. Chong Leong, member of the SIAC Board of Directors and partner at Allen & Gledhill LLP, Mr. Kap-You Kevin Kim, senior partner at Peter & Kim, Mr. Toby Landau, QC, member of the SIAC Court of Arbitration, and barrister and arbitrator at Essex Court Chambers Duxton, Singapore Group Practice, and Essex Court Chambers London. Ms. Yoshimi Ohara, partner at Nagashima, Ono and Tsunematsu, and Mr. Mohan Pillai, partner and head of office at Pinsent Masons M. Pillai LLP, Singapore. Moderating this session is Dr. Eun-Young Park, member of the SIAC Court of Arbitration and co-chair of the International Arbitration and Cross-Border Litigation Practice at Kim In-jang. Dr. Park, please.
Thank you, Michelle. Thank you, everyone. Thank you for those who joined from all over the places. This session is to discuss about the ground rules for the arbitrator, how you should communicate with the counsel when you are approached for pre-appointment, and how you check the conflicts, what you should disclose, and how you should manage counsel and proceeding, and how you work with the arbitrators. So I'll start with the several questions with regard to the first issue. We have a pre-appointment interview issues. You might be approached by a counsel. So then how would you conduct and manage pre-appointment interview? So as to ensure you maintain independence and impartiality as an arbitrator. I would invite Kevin to comment.
Okay, thank you, Y. Actually, I just want to confirm that we should be contacted by counsel rather than party. So sometimes party contacted me. I always said that you must have counsel, the counsel contact. When the counsel contact me, I normally say three things. First point is I just say I'm going to disclose when I was appointed, when I am appointed, and I'm going to disclose that I was interviewed and the contents of the interview. That is my first point. Second point is no confidential information should be given to me. Actually, other than party's identity for the conflict check, I don't want to receive any information about the case. The actual interview should be focusing on linguistic abilities or the experience or the areas of expertise or the workload I have to schedule in the coming years. There should not be anything about the case. So I just want to make sure when that counsel can control that fact. And so in order to make sure that no unnecessary question was proposed, I would request counsel to provide the questions they're going to make to me during the interview. So that is I normally do in order to avoid any potential conflict in the future during the interview as arbitrator. Thank you, Y.
Thank you, Kevin. Yes, going further, there may be methods that should not be discussed at the pre-interview session, pre-appointment interview session. I would invite Yoshimi to comment on this issue specifically. Yoshimi, you are on mute. Okay. No problem.
Sorry. Good morning, everyone. It's nice to see so familiar faces. Thank you for all those who are participating in this session out of busy schedule. This is a really tricky issue I serve as arbitrator and also counsel. As counsel, you really want to know what kind of person this is, this prospective arbitrator is. I usually appoint someone I know very well, or I, once in a while deal with in professional context or personal context, so that I can know what kind of person this, prospective arbitrator is. Because, of course, the selection of arbitrator is one of the most strategically important issues. So you are tempted to ask many questions relating to the merit of the case, but that is the area you should avoid. Why? Because you may be able to get useful information from the prospective arbitrator in relation to the case, but at the same time, you increase the possibility of challenge against this arbitrator, and that will entirely ruin this arbitration proceedings. So just to make sure you check this prospective arbitrator's availability or expertise, whether he or she is familiar with this specific industry or subject to dispute, and specific type of dispute, specific nature of the disputes, but not going to the actual facts, specific facts, or arguments or legal issues to make sure that this prospective arbitrator remain to be independent and impartial. And as Kevin pointed out, nowadays, arbitrators are quite cautious, prospective arbitrators are quite cautious in accepting sensitive questions, because we see more and more cases of challenges. So as a prospective arbitrator and counsel selecting arbitrator, you should make sure that your question is well contained, do not go beyond general nature. So never ask specific, never, share specific facts or circumstances of the case, giving rise to dispute, position of argument of either party, and merit of the case, and in particular, prospective arbitrators' view on the merits. Thank you.
Thank you, Shimi. That's helpful. Arbitration is conducted with a basis of independence and impartiality. So the conflict of interest for arbitrator is a very important one. Normally, conflict is checked in an early stage so that the arbitrator can confirm its appointment. So now, how do you go about conducting your conflict checks prior to accepting your appointment? And also, to what extent you should disclose as an arbitrator? I would invite Mohan to comment on this. Mohan,
hi, thank you. Yes, thank you. Good morning, everyone. I mean, obviously, as EY has mentioned, I mean, this is a fairly routine, quite early stage part of the arbitration, but absolutely critical because any justifiable doubts about the independence or impartiality of a member of the tribunal can have very, very far-reaching consequences and could, if it is not handled in the appropriate way, result in issues relating to the enforcement of the award. So it is a key point and a duty that I think tribunals take very, very seriously indeed. You need a system, obviously, to keep track. My conflict checks tend to focus around three areas in sort of descending order of importance. First of all, any connection with the parties and the dispute. Obviously, this will extend to affiliates of the parties and any connection with the dispute, either upstream or downstream of the dispute. The arbitrator, of course, bears the identity of his firm. And for those of us who work in organizations where you've got partners across the world, you really need to be aware of the involvement of others in the practice, on the project or some relationship with the parties. And sometimes this extends to the firm that you may have come from previously, many years ago. I mean, I've had to give disclosure of a firm that I worked with more than 10 years ago because I thought that was the sensible thing to do, because one of the counsel appeared from that firm and I thought it was right to do that. Which brings me to the second area of conflict checks, and that's counsel and parties' legal representatives. I think you've got to, if you have an appointment history with a particular firm that is appearing before you, that's quite important. If you've got professional relationships with the individual counsel that is appearing, that is probably prudent to make clear, although I think it is obvious to most of us that that doesn't disqualify you. And the last, and I have to say, rarely a problem is any relationship you might have with fellow arbitrators. So these are the three broad areas I look at, and the question of the extent of the disclosure, I mean, every piece of literature you read on the subject always carries this consistent warning: any doubt should be resolved in favor of disclosure. And disclosure doesn't mean that you're conflicted. You'll only make disclosure if the tribunal felt, I can take the appointment, but it is appropriate to let the parties know of this particular piece of information. So I hope that's helpful. Thank you, EY.
Thank you very much. Now you have gone through the appointment process, successfully checked the conflicts, and you are appointed as an arbitrator. Probably the first thing as an arbitrator would do is to hold a preliminary meeting to set up the ground rules. Arbitration has to be conducted in most cost-efficient manner, so it's good to have a preliminary meeting. Many institutions provide rules for this. SIAC rules provide 19.3 to set up this preliminary hearing. Now, what should you discuss and consider at this preliminary hearing? I would invite Kevin and Mohan to comment on. Kevin?
Hey, thank you, Y, again. The first thing you have to confirm with parties would be, in my case, jurisdiction or any procedural challenges. For example, any challenges against the arbitrator or any issues in connection with the arbitration agreement. Because that is important to review and decide whether the procedure could be bifurcated or any separate issue to be decided at an earlier stage. Sometimes the parties have issues with the counsel, conflict with the arbitrator. So that is the first thing I want to confirm. And also, I also want to confirm which parties are exactly involved in the case, listed parties or any other related parties may have some interest in the case. That is also important to check the conflict. It is sometimes the parties may bring in the counsel who might have conflict with the tribunal members. So it's quite typical nowadays the tribunal include a certain procedure order or the agreement with parties to say when they bring in new counsel, you have to receive approval from the tribunal. So that is the first thing I want to check. And the second thing is a schedule. Schedule is quite important thing, whether the case will be bifurcated or just proceeded one procedure, and the how many submissions will be made, and whether or not and when the discovery will be conducted, in what fashion. So that is the second point. The other point is the organization of documents. Sometimes parties already submitted an exhibit with numbers, and then we just have a reorganized documents. It's not efficient. So I normally request the parties to put the right numbers from the beginning so that we can use the numbers to the end of arbitration. So the organization of documents and the document control is another matter. And the witness, how many witnesses we will have, we expect to have, and particularly expert. So when you have which area we need expert on this case, and when you have expert, we can think about just like tribunal members might have a case management meeting with the expert before the main hearing, to sort it out the issues between or among the expert on the case. That is, I normally say that that's quite efficient. So, to narrow down the issues to be dealt with in the main hearing. Normally, the arbitrators have some prepared procedure order number 1 cover the various issues, but normally we share that the procedure order number 1 in advance before we have the preliminary meeting, so that parties can comment on that. That is my practice. Thank you, EY.
Thank you, Mohan.
Yes, thank you. That was pretty comprehensive. So I'm not sure that there are many gaps in anything that Kevin has said that I can fill in, but I'll try my best. I mean, if I can just pick up the last point that Kevin has made, I think the real efficiency in the procedural meeting that we have with the parties at the very start is impacted quite significantly by the preparation that is done for that preliminary meeting. And like Kevin, it is also my practice to ensure that the tribunal gets together in the early stages, works out the kind of information that it would like parties to address at the preliminary meeting, and then send that in advance to the parties so that the parties have an opportunity to think about it, to try and confer, and where possible, reach agreement. Conflict issues relating to ensuring that counsel doesn't change, that's a point that Kevin has covered. We also want to be quite clear that no challenges are being made to the jurisdiction of the tribunal on information that is already known to the parties. The question of what is the seat and the substantive law, that's important issues to get right at the very beginning. It's also my practice to present to the parties a draft of the procedural laws that the tribunal might be keen to use for guidance. The IBA rules on evidence, the Chartered Institute of Arbitrators guidelines on witness conferencing, the protocol on party appointed experts, all of that useful, common, well-known to many of us. We try and present that as guidelines for the parties to consider. And of course, I think one of the most critical elements, which Kevin also touched on, is the procedural timetable. And part of that, I think, turns on how the tribunal wants to manage that process. And of course, the bookend to that procedural timetable is when the merits hearing is going to take place. And I have personally found it helpful in early stages to talk to the tribunal about the complexity of the case, the magnitude of the case, how long we think it might broadly take to bring the case up to hearing, and then present a tentative set of hearing dates to the parties in advance of the preliminary meeting for them to consider, to clear diaries, and then to work backwards from that date in terms of filling up potential preliminary steps. And those preliminary steps would take us through the pleadings, the discovery, but also important issues such as, would the parties wish to consider bifurcation and put a line in the timetable for the parties to take a view on that. But all of this, I think, really helps when the parties do come together. They're not starting off on a clean slate. They've had an opportunity to get a sense of how the tribunal views the proceedings. They've had an opportunity to consider a draft, and they've had the opportunity because, my practice is generally to encourage parties to confer on the basis of the guidelines that the tribunal has presented well in advance of the preliminary meeting. So at that meeting, hopefully we get to identify what are the issues that separate the parties and focus on that.
All right, yes, that helps. Thank you. Next question is to Toby. In light of the COVID-19 situations, we conduct many virtual hearings, do you think virtual hearing become a new standard? And should we consider the virtual hearing to be conducted for all arbitration cases? What do you think?
Thank you very much, EY, and good morning to everybody, and to some people, good very early morning. The question of what has now happened to arbitration post-COVID is an incredibly important point, which is pressing on all of us. There has been a revolution in the last few months in the practice of arbitration, undoubtedly, as well as litigation. And this is a change that has been forced upon us. It's been accelerated really with a community that perhaps has been before this quite reluctant to embrace the full potential of technology and to change their ways. But I think what's also important now is that everybody, all of us, are on a learning curve because this is all new territory. And so quite whether we will keep doing what we're doing now, whether we will go back to what we did before, is all open to debate. I think it's important to pinpoint what the advantages and disadvantages of virtual hearings are in order to answer the question whether they really should be the new normal for all cases. Firstly, in terms of advantages, I think undoubtedly virtual hearings have brought the most extraordinary efficiency and economy to the arbitration process. In the pre-COVID days, we had reached an understanding of due process, which meant that people would unthinkingly climb on and off aeroplanes. People would travel for even the shortest, most anodyne procedural meeting. I would travel sometimes hours across the world for a hearing that might just be half an hour or half a day. That was indefensible from an environmental perspective, but it was something that people expected. And if somebody said in the old days, I want a personal hearing, due process was understood to mean, well, you have a right to be to have a hearing in person. What we've now done in the space of a very short period of time is recalibrate due process. I think with the assistance of courts as well, because they're doing the same thing. So now it is customary, it's expected that we will not travel. And what that means is a huge saving in not only costs, but time. It means that diaries have opened up. People are more accessible. It's harder for people to say, I simply can't attend a hearing, because you can attend a hearing at home at any time of day. And I think that is something which will stick. That's not going to change. Secondly, I think the remote hearing mechanism has brought a greater discipline to hearings. There are natural limitations to how long you can speak at a camera, and perhaps more importantly, how long you can watch a screen and pay attention. There are difficulties in communication over a virtual link. And that means that advocacy has had to become shorter and more focused. And probably more weight is now being put on written submissions. Expecting a tribunal to look at a screen for hours on end is unreasonable, and even if they agree, may be unproductive. So I think the discipline means that hearings themselves have become more tailored, more focused, as they always really should have been. Thirdly, as part of the efficiency, we have now become all adept with electronic bundles, because that's really the way that remote hearings work. Electronic bundles are incredibly efficient. They've been there for many years, but there's been a reluctance to use them. And there's been a default to production of huge volumes of paper, as well as the electronic bundle in many cases. Now people have been forced to get used to PDFs and bookmarks and navigating through an electronic volume, which actually is much, much faster in the end, much, much more efficient. I think the fourth point I'd say is that there's a leveling that's happened and there's an access that's opened up. In the old days, actually traveling to a hearing wasn't possible for everybody. And so it wasn't always possible for everyone who wanted to be at a hearing to do so. Now they can. Now anybody can log on. And it means that actually more of the clients can attend hearings. Legal teams can easily attend hearings in all the numbers that they want to. And as long as the access to IT is even overall, that is a leveling across parties who may have different financial ability. In the old days, some parties could finance bigger teams traveling than other parties. And I think lastly, what I'd say is that it also has an interesting impact on witness availability. The idea now that a witness is not available to attend and testify it's a harder argument to make, because witnesses can attend anywhere, just as parties and counsel can attend anywhere. So I think those are a range of advantages, which means that this new system will remain. There are, however, disadvantages. I'll run through them very, very quickly. Advocacy is extremely difficult over this medium. I'm now looking at the camera, but I'm not looking at anybody's eyes. My temptation is now to do this and look at my fellow panel members. So I can see your reaction now. I can see how bored you are, how much you disagree. I can measure what your feelings might be. I can read you, as I want to do as an advocate, but for you, you're not looking at me anymore because I'm looking at you. So I have to do this, which means I can't see you anymore. I can't read you in the same way. And that's actually, there's a whole craft that's now missing. It's not just eye contact. When you're in the same room, you will read body language. Both tribunals reading counsel and counsel reading tribunals, you will read the body language of your opponent. You can't do that now. So there are limitations. That's amplified with witness examination, cross-examination. It's very difficult remotely. Difficult for a witness to feel the same gravitas of the occasion, perhaps the same pressure, the same solemnity. Difficult to deal with a witness when to bring discipline to an examination. Difficult to conduct a long examination. Difficult to deal with documents often. That's also true of experts, and it's made 1,000 times harder if there's translation in between to coordinate that. There are, of course, logistical problems. Time zones, as I can tell you, because I'm speaking at an uncivilized hour. IT differences, because sometimes IT works better in some places than others. And overall, there is an intensity about remote hearings that makes it difficult to do them for very long. So if you put all of that together, I think the question, will this be applicable for all hearings in the future when we have a choice, hopefully? The question will be the nature of the hearing. This is ideal for procedural hearings, for short hearings, the hearings that are not too controversial, interlocutory matters. It is less good for heavy witness examination hearings. And that's, I think, where we may well build up a new system of hybrid hearings, where we can meet, or some people can meet, or some witnesses can attend, but other parts of the process or other participants can be handled remotely. Thank you.
Thank you, Toby. That's very thorough analysis. The due process concept remains the same, as you mentioned, but probably the content of the due process might have been transformed throughout this COVID-19 situation. Maybe the concept of due process is transformed in the arbitration community, but it may not be the same for the courts, especially some tough jurisdiction. So there may be some discrepancies or tensions in terms of consensus to conduct the arbitration virtually, but at the same time, whether it be smoothly enforced in every jurisdiction. That would be certainly an interesting phenomenon that we might observe down the road. Thank you. So the next question is on the managing counsel and proceedings. So now I will address three scenarios to Leong for his comments. How would you deal with the three scenarios? Like, firstly, multiple requests for extensions of time be made by one party. Second, what if there are constant frivolous objections raised by one party? And thirdly, a party tenders new evidence late in the proceeding. How will you do that to react? Leong?
Yep. Thanks very much, EY. Good morning, everyone. In relation to the three scenarios that have been presented, actually the underlying themes to be considered by the arbitrator in dealing with them actually are the same. It is the tension between the duty of the tribunal to manage the arbitration in a fair, expeditious, economical, and fast manner, compared to the ability of parties to present their case. Obviously, the parties who's trying to raise the frivolous objections or have multiple requests for extension, they may be doing it, okay, with a view to challenging the award if the decision should be rendered against them or their client. And that is something that the tribunal has to be careful about, because there's always a complaint about due process, complaint about not being able to present their case properly. And on the other hand, you also have to be, as a tribunal, you have to be concerned that the process is not taking too long. And particularly as Kevin and Mohan have said, you have set out the timetable in procedural order number 1. And most of the time, the merits hearing will have been fixed because you have diaries of at least 3 parties, if not 5 parties, if you have a 3-member tribunal. And it's difficult to get a common date where everybody is available. And if those delaying tactics threaten to delay the merits hearing, then the consequences will be quite dire and serious, because you may not be able to find a common date many months down the road, until it's many months down the road. So in dealing with that, you've got to consider all these factors, the efficiency with the ability to present the case. And if most of the time, for example, if an application for extension of time does not impact the merit hearing, but it can be accommodated with some adjustments of the procedural timelines, then it is usually not a big problem and can be accommodated. But if too many of these applications for extension of time is made, then the tribunal will have to start considering whether they should allow it, and or if you allow it, what are the things that you can, what are the arsenal that is available to the tribunal to deal with it. Generally, I think the most simple way of dealing with it is to deal with it by way of cause. And that's how most common law tribunal or common law traditions would deal with it, as in that if the disruption caused additional cost being incurred by one party, then you make a note of that and you deal with it either then as in a cause order, or you deal with it at the merits at the end of the day. But if it cannot be compensated by award of cost, then you could start thinking about other things that may be imposed. For example, if you can make an adverse inference that can be made because of the multiple requests or because evidence are tendered late, and you will place less weight on the evidence because it is put up late. And obviously that would depend on the reason for the evidence being adduced late. And I'm sure all of us who have been counsel have encountered situations where the client brought up something to you very late in the day, which you think are very relevant, and you have to put it in. So obviously those factors have to be taken into account. Or of course, the most drastic measures that the tribunal can take is to exclude the piece of documents or to exclude the evidence altogether. But obviously that's something that is very drastic and should not be resorted to unless there are very good grounds for doing so. Like for example, where it's obvious that one party is really trying to disrupt the whole proceedings by bringing something that's completely changed the case at the very last minute. Those are things that you will consider. So it's a weighing exercise, like I say, and there's no one-size-fits-all answer. But in each unique situation, you got to weigh the two and use the arsenal that you have at your disposal to deal with the situation that you have. That would be my general answer to the 3 scenarios. Thanks, Ivan.
Thank you very much. Now, suppose that you are appointed as an arbitrator. You might sit as a sole arbitrator, but on many occasions you are a member of the tribunal. So after you hear all the matters among the arbitrators you deliver within the tribunal, then the problem is that how you effectively work with your co-arbitrators, member of other arbitrators. This question is again to Toby. What do you do in the event that your fellow arbitrator appears to be partial or biased toward the party that appointed him or her? How do you deal with this situation?
Thank you, EY. Of course, the beginning point is that all arbitrators must be neutral, independent, impartial, so that even if you are appointed by a party, you have to forget all links and all loyalty that you may feel, all feelings of kindness and gratitude you have to put out of your mind for having been appointed, and you have to be totally neutral and not predisposed. The reality is that one does come across arbitrators who are party appointed who appear to have a predisposition. And that can come in different strengths. It can be subtle and it can be obvious. I think it's worth pointing out that generally any predisposition will be counterproductive, because you have to, if you are predisposed and you are biased, then that is likely to become obvious to the two other arbitrators, which means that you will become sidelined in the deliberations and your views will no longer count in the same way. So there's a process of self-destruction if you are predisposed. But it can be subtle. There are times where you don't quite know whether an arbitrator is predisposed or not, but you get a sense that every contribution that he or she makes seems to be in one direction. And that is quite difficult then to call out. I just want to mention that there are very interesting dynamics that happen amongst arbitrators that people often don't talk about. But in the inner workings of arbitral deliberations, people do a fair amount of maneuvering to try and show their neutrality early on and gain credibility with the other two arbitrators. This can happen sometimes quite obviously. You can have an arbitrator appointed by one party who very early on will take a very, very strong stand against the party that appointed him or her. Mm. But interestingly, it's often on an incredibly unimportant issue. So that's where it can be misleading. So a co-arbitrator may have a violent reaction in the deliberation room against their party that appointed them, saying, I think that that submission is outrageous, we should definitely dismiss it. And that submission might be for something very trivial, about a short extension of time or something. So you can never tell because there's a maneuvering that goes on, and it may be that that's a longer game plan, whereas so that having shown that they're neutral, they then go for the kill on something that does matter. I think in terms of answering the question, there really are two different categories of situation that one should distinguish. Firstly, an arbitrator that's showing a predisposition during a hearing and an arbitrator that is showing a predisposition during deliberations. Both of those happen. Both have to be handled differently, in my view. When an arbitrator is showing a predisposition during a hearing, I think that it does become incumbent on the other members of the tribunal to balance out what is happening. And that is to preserve the integrity of the arbitration. If you don't take an affirmative step to try and balance, then the whole process may be jeopardized later if an enforcing court or a court supervising court looks at the transcript and is met with an argument that the tribunal was biased. That happens frequently. People will look at the transcript and say, look at these hostile questions from this one party. The tribunal was not fair. So you need to counter that, and you can counter that in a number of ways. Sometimes you actually have to speak to an arbitrator outside of the hearing, which happens, to say, please don't ask questions in this way, or please be careful. If that doesn't work, there is actually a balancing that can be done by asking hostile questions in the other direction. And that actually does balance things out. If you've got one party appointed arbitrator that's firing questions at one party, I feel often I will fire questions at the other party. because I want it to be balanced. It's an unpleasant experience for the parties, but it means it's level and even. But lastly, when you see that predisposition in the deliberation room, then really it's a question of interpersonal skills. It's a question of making sure that the third arbitrator is aware of what you are picking up. You need to somehow diplomatically make sure that the points that are coming from one side are labeled and called out as being biased. Not in terms, you're not going to point the finger and say you're being biased, because that may be a breakdown in the deliberations, a breakdown in the tribunal relationship. But there are diplomatic ways of observing that all of this seems to be pointing in one way, that there are counter arguments that are not being looked at. It's a bigger burden on the other arbitrators to bring forward the counter arguments. But in my experience, normally a predisposition doesn't actually influence, because it becomes obvious, and then the two other arbitrators effectively switch off and the dynamic changes.
Thank you. Thank you for sharing insightful thoughts. The next topic is on the very common issue arising in arbitration, that is the common law, civil law divide. Are there any differences working with the civil law arbitrators and the common law arbitrators? Are there any cultural differences when working with arbitrators from different jurisdictions? Thanks to the variety of our panel, we have arbitrators coming from civil law as well as common law. I invited Yoshimi and Leong to comment on this issue.
Thank you very much, EY, for this introduction. I'm sure everyone had some familiarity with the difference of court proceedings in civil law jurisdictions and common law jurisdiction, but there has been conversion of proceedings, arbitration proceedings in civil law jurisdiction and common law jurisdiction. But you may question, particularly in selecting arbitrator, whether you should choose someone from civil law background or common law background, depending on your case, because you are in belief that that background may affect the organization of the hearing or conduct of arbitration or directions by the tribunal. And short answer to your question, based on my experience, there are certain, well, I wouldn't say, you know, there are dichotomy among arbitrators coming from civil law jurisdiction and common law jurisdiction in terms of approach towards the procedure matters. But I would say arbitrators from certain country may have particular tendency. I would not go into too much far on that point, but at the end of the day, what matters most is the case and also how each party presented each case to the tribunal. As everyone know, civil law jurisdiction the court tend to take more inquisitorial approach, and in common law jurisdiction, court takes more adversarial approach. So the tribunal or the court will not ask questions too much in common law jurisdiction, in civil law jurisdiction, and in terms of document production, substantive document production is more related in common law jurisdiction, the court in the common law jurisdiction, but less related or not even available in the court in civil law jurisdiction. But when it comes to arbitration and arbitrators, in my experience, as I mentioned, if it all depends on how the party presented the case. If party sort of fail to make a case clearly, even civil law arbitrators coming from civil law background really want to have evidence submitted by the parties they tend to become more tolerant to substantive document production. So if you make a good case, regardless of whether tribunal members coming from civil law jurisdiction or common law jurisdiction, they may not be tolerated to substantive document production request. So short answer to your question, there's no dichotomy between arbitrators coming from civil law jurisdiction or common law jurisdiction. It will depends on the nature of the case and how the case has been presented. Thank you.
Thank you.
Yeah, thanks very much. Thanks very much, Yoshimi. I think you have struck the nail on the head when you say that there's really not much of a difference between the two. And frankly, given my experience in the arbitration world, where I have had numerous interactions with common law and civil law arbitrators and counsel, actually, I believe that there has been a convergence in terms of approach to commercial arbitration that have taken the best of both worlds, the common law and civil law tradition. And I think nowhere is this actually exhibited with the recent introduction of the Prague Rules that was introduced 2 years ago in 2018. And that Prague Rules was actually introduced sort of like as a reaction or an answer to the IBA rules for taking of evidence, because it was said that the IBA rules of evidence was too common law based, okay, and reflect too much of a dominance of the common law procedures in commercial arbitration. And a group of civil lawyers have come together and introduced the Prague Rules, which took them about 4 to 5 years to introduce a set of rules that are more inclined to the civil law traditions. And why do I say that the introduction of the Prague Rules actually underpin the similarities between the two systems? If you actually analyze the Prague Rules, at the end of the day, it's not really that different from the IBA rules of evidence, right? They introduced power for the arbitral tribunal to take charge of the proceedings, but actually in the IBA rules, there are already provisions for the tribunal to take charge to appoint its own expert, which is what the Prague Rule says. The tribunal should appoint its own expert, but IBA rules also provide for that. In terms of documents production, yes, the Prague Rule says that you can only ask for very specific documents as opposed to categories of documents. There is difference there. But in terms of examination of evidence of witnesses, the Prague Rule says that the tribunal can ask questions and should lead. And in fact, that is also something that the IBA rules provide for, that tribunal can ask questions and ask any specific production of any specific documents. So all these actually underpin the similarities more than the differences between the two systems. And in fact, from my interaction, I think that tribunals now are very, very practical and pragmatic about things. They are not dogmatic. These are soft laws that have been introduced to guide the tribunals and the parties as to how evidence should be introduced and how the proceedings should be managed. But the most important thing, like Yoshimi says, is actually the merits and how the procedures and the rules of evidence should be tailored to actually match the particular unique fact situation in that proceedings. And that's what I have seen being worked out by tribunals, whether consisting of all common law, all civil law, or a good mix of both. I don't think anyone is slaves to any particular tradition, but all we are trying to do is really to facilitate and to make sure that we get the best evidence from the parties. That will be my stand on that. Thanks.
Thank you very much. These are all very good comments and answers. There are a number of questions presented to the panel from the floor. I gathered those questions, and thank you for those who submitted questions. I'll try to cover as much as possible given the limited time, but I will invite our panelists to make a comment. The first question I would like to address to you is non-participation by the respondent. What if respondent does not participate in the proceeding? In that circumstances, do you still need to proceed to hold a hearing and examine witnesses. I would ask Kevin to comment on any others to join if possible.
Yeah, thank you, Wai. You know, as you know, the international arbitration or the arbitration in any jurisdiction, you don't have default judgment system. So you have to proceed arbitration as planned, despite that one party failing to participate. But actually, what my experience, sometimes tribunal pay more attention to the procedure when one party failed to participate, and all the tribunal members, if you have 3 tribunal members, in case of non-participating the party situation, normally we have the 3 tribunal members all appointed by the institution. Then everybody became very neutral, very impartial, very interested in the procedural matters, to make sure that all the legal elements of the case is properly met. I see some, not every case, you know, normally, you know, when non-participating party have no opportunity to present their case, they will be in the weak position in the end. But sometimes the non-participating party have some benefit. Actually, the tribunal members very cautious, ask very difficult questions to the parties who participating, and very strict rules in the deciding the legal elements of the case. So you should be careful when you are participating arbitration and the other party is not participating. Don't underestimate the situation, and you should be careful to make sure that all legal elements is properly met, and the witness and the evidence you present should be sufficient to meet the standard to prove the case.
Thank you. Maybe we may move on to the next question. That is, the specific question is to hybrid hearing, as Toby addressed earlier. If a tribunal decides that there should be a hearing, and then there's some suggestion of split hearing, a Singaporean-based claimant can attend the hearing with the tribunal in a physical manner, but the respondent is not able to come to Singapore and they will join virtually. So would it be allowed, or should the tribunal order a virtual hearing for all parties because of the concern of fairness? So I will open this question to the panelists if anyone has any comments.
I'm happy to dive in.
Yeah.
I think the short answer to this is that it is extremely dangerous to have a hybrid system in this way, where there is an inequality between the parties as to whether they are present or not. It would only be advisable when you have got everybody's clear consent. If everybody clearly consents, then there can't be a complaint later. If they don't consent, then the system will be unequal between the parties. And that's for the reasons that I outlined earlier about the nature of remote hearings. It is not the same to be addressing a tribunal through a camera as opposed to being in person and having that physical connection. And that is something which will easily sow the seeds of a challenge later. There's a golden rule that you have to have in mind as an arbitrator in every decision you take. In fact, you have to have it in mind as counsel as well, from the beginning of an arbitration to the end. The golden rule is that the most important thing ultimately is the recognizability and enforceability of the award. So every decision you take on any matter, you have to test against that. Is it possible that the result of your decision might be a setting aside application or an argument to defend against recognition and enforcement of the award. And that qualifies many of the decisions that you will take. So to my mind, this one is an easy one. It's too dangerous to do this unless everybody agrees.
Okay, yes. Well, thank you.
Could I just pick up on that
please,
point?
Please.
And I think the point that Toby made about the enforceability of the award is something that most tribunals will always have at the forefront of their mind, and perhaps not more so than when you've got a respondent that isn't participating. So it's a helpful point if you will allow me to just go back to the first question. And when you've got a respondent that doesn't participate, the tribunal is very, very concerned about the potential impact that might have on the enforcement, because I think the fear that most tribunal and counsel on the part of the party that does appear is that the respondent is going to wait till the award is rendered and then challenge it on some technicality at the enforcement stage. And so the enforceability of the award becomes particularly important in terms of the tribunal making every effort to ensure that proper notice is given. And to pick up the point that Kevin has made, many tribunals will then take on some part, not in its entirety, but some part of what counsel for the respondent would have done in testing the evidence, so that it can't be said that the tribunal simply accepted without question, without interrogation, the evidence, and that might reflect on the tribunal not being sufficiently impartial. But I think the question of enforceability of the award becomes particularly important if you don't have equality between the parties. And I think that's particularly obvious when a respondent declines to participate in the process.
Yeah, thank you. The next question is related to the, I guess, pre-appointment interview issue. The question is this: how will you explain to the parties' counsel that you do not want them to discuss specific facts, especially when the party counsel is so insistent in disclosing certain facts? Anyone to comment?
I think I can think that I think the prospective candidate for the nomination or the appointment has to put his feet down. I think that's something that no compromise can be made, and that should be made very clear to the interviewing party right from the word go, that no discussion on the merits of the case can be undertaken, because frankly that to do that and you will have to risk the fact that it will be discovered later. And in fact, for a true transparent process, the candidate who has been interviewed should in fact disclose that once it's been appointed to the other parties, and that may well unravel the whole appointment. So I don't think it's something that can be compromised. It has to be very clear. But if one of the if the interviewing parties insist on carrying out the discussion on the merits, then I think the prospective candidate should actually not carry on with the interview.
Yes, certainly. I think that practically when the prospective arbitrator is approached by the counsel for the pre-appointment interview, I guess that what the prospective candidate could do is this, to reply to the counsel that interview is possible, but I assume that there is no discussion on the merits. So, so then he would lay a foundation for the interview. To that end, I think that as long as the counsel agrees the assumption and proceed with the interview, I guess that the candidate would have a good understanding that the merit is not discussed.
Could I come in with another observation?
Yes.
In my experience, what frequently happens, this is no exaggeration, what frequently happens in these interviews is you will have an understanding with those who are interviewing you that there'll be no discussion of the merits. And in the course of the interview, what they will say to you is, Now, I want to ask you this question. This has got nothing to do with this case. We're not talking about the merits of this case at all. But hypothetically, if you were faced with a party who is a fraudster and has a tendency to forge documents, what would be your approach to applications for disclosure of documents? It's that kind of question. So the question is, we're not talking about anything. I'm not telling you about the facts of this case. I'm not saying anything. I just want to know theoretically, what's your position on this kind of thing? And sometimes the question will be generalized a bit more, but still dangerous. The question will be things like, what is your general approach to applications for disclosure of documents? And that starts to get you onto an area where you will be answering questions that might prejudge actually what you're going to be asked to do in this particular case. That's why they're asking you those questions. So that's where it can be difficult to draw the line. And my sense is you have to be absolutely clear from the outset, throughout, that you won't answer the questions. And very frequently in these interviews I've had, I simply say, I'm not answering that. I can't answer that. And the other thing I do is I frequently have somebody agreed beforehand who will take a note of the interview. And I make it clear that a note will be taken and that I will disclose that I've had this interview. And if requested, that note will be shown to the other side. And that can be a huge deterrent to anybody trying to push you over the line.
Yes. There may be a blurry line as to what would be acceptable and what is not. Obviously, we all agree that the merit is not be presented to the prospective arbitrator. But the arbitrator may want to know about the nature of the disputes. So is it allowable for the intervening party present the nature of the case by describing the position of the parties evenly? So claimant's position is this, respondent position is that, so it is described in most neutral manner, so then the arbitrator can understand the nature of the dispute. Is it allowable?
May I?
Sorry, Yoshimi,
Please.
carry on.
No. Okay, thank you very much. It is a really dangerous area. Of course, as counsel, you're tempted to ask those questions, but explaining parties' arguments by the party, one party, without the presence of the opposing party, it is quite dangerous. You're stepping into the area of jeopardizing impartiality of the arbitrator. So general nature of the case, so long as it is really general, to the extent necessary to check the expertise and ability of the prospective arbitrator, that should be permitted. But anything beyond that line, counsel should not make that kind of question. And also a prospective arbitrator should stop or prevent the interviewing party from continuing that line of questions.
I see. Any other views?
Actually, I was about to say that describing the nature of the dispute with a very short summary of the position of party may be acceptable in the conflict check situation where you're trying to check whether you are conflicted from undertaking the arbitration proceedings because of conflict, but certainly not phrased in the form of a question asking for the views of the prospective arbitrator as to where he stands or what position in relation to the dispute. But if it is just to enable him to understand the nature, I don't see a problem, provided he's not asked to comment on it.
Okay.
I would just jump in and say that one person's view of neutrality may be different to another person's. You can give a description of a case which you think is neutral, but within it you may already be effectively making a submission. I can say to you that this case is about a major investment in a country. But if the opposing party doesn't believe this was an investment, I've already said something to you. Unless I even that up by saying, but of course the other side say this is not an investment. So I think it is dangerous. The better thing to do, what I normally do, is if I want to know about the nature of the case, I will ask for a copy, if it exists, of the notice of arbitration or the request for arbitration, and I will get a sense from that. And of course, if there's an answer, I'll want to see that. And that should really be all that you need.
Okay, thank you. All right, maybe we can move on to the next question. That is a dichotomy between memorials and pleadings. The question is, which style is preferred for you? Personally, as an arbitration, especially arbitrator. So do you prefer memorial style or pleading style?
If I may, actually, seems like
Yes.
it really depends on the case. I understand that some jurisdictions strongly prefer pleading style. And in the memorial style is, I'll say, is more efficient, the quicker, not necessarily quicker, but it's normally quicker than the pleading style. But if you're dealing with many experts on the case, for example, if you have the time expert, quantum expert, engineering expert, together with some financing expert in a dispute arising from the big project, maybe pleading style may be more efficient, because you have to sort it out the expert issues after you sorted out the arguments between the parties. I think you should look at the case and which way is more efficient, rather than just following the practice, a particular counsel or the arbitrator just preferred to or more familiar with. So the counsel and the arbitrator should be neutrally minded to decide whether the pleading style or the memorial style would be preferred. Sometimes with a hybrid system, we just proceed with pleadings together with witness statement, and only for the expert, we just have an exchange expert in the middle. As I told you before, one of the trend in certain type of dispute is that the tribunal members more active in communicating with the expert and sorted out that the dispute or disagreement between the expert in advance. So in that case, maybe some hybrid system is also work.
Okay, thank you. The next question I received is interesting. It really touches upon the fundamental nature of arbitration. The question is about, do you consider more an equitable outcome for all parties compared to the strict court litigation? So arbitration has been known as something, you kind of facilitate a amicable resolution from the history, but now there's a observation that the arbitration becomes more similar to the court litigation. It's almost like a private litigation. Still, do you pursue an equitable outcome, or you are abiding by the law in making a determination? That's somehow a fundamental question. Can you comment on this?
I'm happy to have a go.
Yes.
It's a very, very interesting question and a very important question. To my mind, you have to distinguish between two different aspects of the arbitration process. Firstly, there is an aspect of what the process looks like as a procedure. Is it as confrontational as litigation? Or is it a process in which you are able to bring the parties together in a different kind of atmosphere, less confrontational, less formal than litigation, that might itself be conducive to settlement or conducive to some other compromises? But secondly, differently, to my mind, at the core of arbitration is actually the determination of the dispute in accordance with the governing law. And unless the parties have authorized the tribunal to depart from the application of the applicable law and the applicable rules, and they're free to do so, if they haven't done that, then that core process is actually no different to the approach of a judge applying the same law. So that ultimately you do have certainty. This is not a free-for-all. Arbitrators must be disciplined, and they have to apply whatever law applies to the dispute. Of course, there may be flexibility in what that law is and choosing that law, and that flexibility itself may be different from a judge. But ultimately, it's got to be a disciplined, reasoned, principled outcome. And the minute we depart from that, arbitration becomes something unpredictable, uncertain, and possibly dangerous. Of course, you can have, as I say, you can have that. You can have ex aequo bono arbitration, it's called, or arbitration in accordance with broad principles of equity. Almost every system will recognize that, but that's subject to the express agreement of all parties to authorize the tribunal to do that. But if they haven't done that, then I think the expectation is that parties' relationship will be determined in accordance with the rules and that apply to it.
Thank you, Toby. In relation to this, I would close with the final question. That is another fundamental issue. I'm glad that our participants brought up really big and fundamental issues for us to talk. We are talking about independence. We should be independent from parties, counsel, whatever. But are we independent from our own? We are raised and educated in our home, civil law, common law. So we say that many former judges are carrying their litigation baggages. But what about us? Are we, looking at the facts and the law using our goggles? If my goggle is tainted by my home jurisdiction, education, and self. So how can you become independent from yourself? How much you are neutral, even from your own upbringing and your own education? We have to achieve the goal of answering this question within 2 minutes.
Okay, maybe I have a go at it first. I don't think when you appoint an arbitrator, you are appointing a blank sheet of paper, right? Every arbitrator will comes with him or her, the prejudices, the background, the experience that he or she has in terms of law, in terms of practice, in terms of life experience, in terms of upbringing. And that is why I think parties actually conduct pre-appointment interviews to make sure that they get an arbitrator that is suitable for the case itself, and to actually ask for a arbitrator that is free from all prejudices and free from all or in a sense neutral of itself is actually a pipe dream as far as I'm concerned. And that's why the appointment of arbitrator is such an important process in the whole proceedings. That is my very short comment on that.
Okay, yeah.
Because part of the answer, EY, may lie in the days when arbitration is going to be conducted by artificial intelligence, which can completely disassociate itself, from the human experience. But I think until that happens, and Leong's point is something that's realistic and just recognizes that we are the product of our own experience. And very often that is why a party has confidence in wanting to appoint a particular arbitrator, because they know that this is an arbitrator with a reputation, with integrity, with a approach which is fair in running an arbitration. And sometimes that is a benefit in coming from an arbitration background, because parties do have the opportunity to decide who is going to determine their case, unlike litigation where you don't have that opportunity. So I think most parties see that as an advantage rather than a disadvantage, knowing the tribunal that is going to look at your case.
Thank you.
Just a very quick comment on Mohan's postulation of an AI arbitrator. Even AI actually comes with their own baggage because it depends on what algorithm that is put in it.
It is. Well, this has been a very productive and interesting session. Thank you very much for all speakers, especially for those who joined very early in the morning. I also thank all the participants for putting good questions. Thank you, and this has been very productive. We close this session. Thank you.